family members, members of the media, we have called this press conference today to refute and to put on records the fact concerning the false and malicious allegation by the Nungua Stool. The attention of the Okpolo-Sowadin family, who are the allodial owners of persons in possession of the major land, has been drawn to a recent interview by the Nungua Stool, led by Benjamin Kwame Danso and George Otibonsu, during which a false, misleading, and highly defamatory claims were made to the general public. But the major people are not surprised because the said individual leading the charge for the Nungua Stool has always been dishonest and a blatant liar. At the said interview, the Nungua Stool recklessly alleged that the brother of the President of Republic of Ghana, Mr. Alfred Mahama, and Baba Sule were sponsoring the Okpolo-Sowadin family. This allegation is completely false, blameless, and malicious. We are very much surprised that a man, Benjamin Kwame Danso, who is nurturing an ambition to become the Greater Accra chairman of the NDC party, would go to an extent of disparaging the President of Republic of Ghana, who has appointed him to the Land Commission Board, just because of his selfish interest. For the avoidance of doubt, Mr. Alfred Mahama, Baba Sule have absolutely no involvement whatsoever, directly or indirectly, in the affairs, activities, or customary matters of the Okpolo-Sowadin family. The statement made by the Nungua Stool is a deliberate attempt to misinform the public, politicize a traditional and a land-related matter, and unfairly prejudice public opinion against the Okpolo-Sowadin family. We consider this conduct irresponsible, defamatory, and calculated to cause reputational harm, not only to the Okpolo-Sowadin family, but also to the innocent private citizen who has been wrongly mentioned without justification. Fellow Ghanaians, we have deemed it necessary to address public following the circulation of false, misleading, and legally unsustainable claims by Benjamin Kwame Danso regarding an alleged contempt action involving a police officer by the name Vance Gariba. We wish to place the true facts on record as follows. 1. Officer Vance Gariba has never been served with any court order, application, or legal process relating to the matter being discussed. 2. Officer Vance Gariba has never appeared before any court with the said individuals and is not a party to any proceeding involving them. 3. In law, a contempt application cannot be sustained against a person who a. has not been served with a court order, is not bound by such an order, and has not willfully disobeyed any law directive of the court. Contempt of court is a serious quasi-criminal process. It is not founded on rumor, propaganda, or public speculation. The law requires straight proof of service or actual knowledge of the valid court order, followed by deliberate disobedience. None of these legal requirements exist in this case. We therefore serve notice to Benjamin Kwame Danso and his Nungua Stool to cease immediately from circulating any falsehood, desist from abuse of court process for propaganda purpose, and also to stop using the name of the police officer to create fears, confusion, or undue public sympathy. They should also take further notice that all legal options remain open, including but not limited to action for defamation, abuse of court process, and malicious and reckless publication. Again, the Nungua Stool, led by the Benjamin Kwame Danso, chairman of the NDC Krowo constituency, in their previous conference deliberately lied to the people of Ghana that Major has no judgment plan, when in fact, and to the knowledge of this Benjamin Kwame Danso, a member of the Land Commission Board, The Okpolo-Sowadin family judgment plan, together with the Supreme Court judgment, was made available to the police CID headquarters in Accra on several occasions. The Okpolo-Sowadin family has lawfully pursued its matters through recognized legal and customary channel, and the ownership of Major land has long since been finally and conclusively determined by the Supreme Court of Ghana. As of 5th May 2004, in a case of Ajete Ogbosu and 5 others, versus Ebenezer Nikwe Kote and 2 others. This celebrated judgment remains binding and unimpeached, well documented and known by all courts, judges, lawyers, legal academics, and students. It is very shameful for the Nunguas to making a statement that Major judgment does not affect them when the Court of Appeal on 4th May 2015 had long determined the ownership of Major lands in favor of Okpolo-Sowadin family, and its previous entitled as against the spurious claims of Nungua Stool. This was in the case of Jake Kwatin Echampon versus Ampofu Eduse and Ano. Civil Appeal number H1/8A/2 2013, per the judgment of His Lordship Justice Aduama Osei. Again, on 31st day of July 2025, Nungua Stool, led by Benjamin Kwame Danso, filed an injunction application in the Accra High Court. This matter was dismissed, and the court made it clear that Major land belongs to Major. Suit number LD/007/2025. The Nungua Stool, again on the same matter, filed another injunction application at the Tema High Court, which has already been dismissed. This completely is abuse of court process. We therefore demand the following: an immediate public retraction of false allegation by the Nungua Stool, a clear and unqualified apology of the Okpolo-Sowadin family to Mr. Alfred Mahama and Babasule. Failure to do so will leave the Okpolo-Sowadin family with no option but to pursue all available legal remedies, including action of defamation and related reliefs without further notice. We urge the general public, media houses, and all stakeholders to disregard all false statements made at the said press conference and to exercise caution in amplifying unverified and misleading claims. Thank you.